In real life, in family law practice, we settle minimally 85 to 90% of our cases. And this office is probably closer to about 95%. It's been a huge change in my practice. I was actually hired by this firm some 30 years ago. If you're counting, I was 6 years old at the time, okay? And I was hired out of the DA's office to be the firm litigator because we had so much litigation. And I was in court constantly, trying cases, temporary hearings before the family court commissioner, trials before the court, pre-judgment, post-judgment, and we had a fairly good appellate practice. So fast forward to today, when getting into court and litigating a case is rare. Some of that I credit towards a change in societal thinking, which is that the job of lawyers should be more problem solvers than problem creators, and that lawyers can do a better job, not as good a job, but actually a better job for their clients, getting them to resolve issues. And a lot of it I credit towards mediation, which is, if not mandatory in every county, at least good lawyers won't litigate a case without trying mediation first. And good mediators are really sensational at getting people to come to an agreement. That being said, one of the things that I've written about a number of times, and it bothers me in this field, is that when you look at CLE programs that are put on that lawyers have to attend, it seems to me that about 90 to 95% of CLE programs are on how to litigate cases. I'm making that statistic up, but probably not too far off, which means that about 90 to 95% of CLE cases are teaching lawyers what we do 5 and 10% of the time, and only 5 to 10% of CLE programs are how to negotiate and settle cases. And the reason that's important is settling cases seems to be intuitive, something that we just do naturally, but it's not. There's a lot of literature out there, there's a lot of science out there, there's a lot of psychology out there that could help lawyers not just negotiate, but negotiate better. Most lawyers, I think, feel that they don't need to learn about it because it's fairly simple. Depending which side you represent, either start with a high offer and negotiate to something lower, or vice versa. And that type of what's called positional negotiation does have a place in this field, and there is literature and studies that discuss the value of it. But there's a lot more to it than that, and there's a lot more than not just being a negotiator, but being a good negotiator that lawyers should familiarize themselves with. In this month's flu, in my From Gregg portion at the very beginning, I discuss a new book that came out, and I'll talk more about that in a second. But what I want to discuss in this video is that there is a significant amount of literature out there that lawyers should be familiar with, learn from, take CLEs on, in terms of not just negotiating cases and the value of negotiating cases, but how to be better at it. The seminal work, of course, in the first place you have to start in learning to be a better negotiator, is the book Getting to Yes by Fisher and Urey. Urey is U-R-Y. It's not a real long book. It's not real difficult to read. It came out many, many years ago, but Getting to Yes is sort of the Bible of negotiations, and everything that flows to it, from it actually, in terms of negotiation, really starts there. After that book, the next best book, I brought props today, is the terrific book by Gregg Herman. How modest he says that. This is a book I wrote for the ABA Family Law section called Settlement Negotiation Techniques in Family Law. It's available through the ABA Family Law section. Go to aba.net to Family Law section and find it. And what I've done in it is discuss various different aspects of negotiations, how to be a better negotiator, and I'll stop bragging about it at this point. I do have a chapter in the book, however, entitled How to Be a Better Negotiator and Where You Go From There, that discusses some of the context I'm discussing in this video. There are a couple other books, though, that are more recent. My book's, I think, about 2 years old now. But two books came out in the last year that I think are really, really helpful to this field. One of them is by my friends Allan Koritzinsky, a now retired divorce lawyer from Madison, and Dr. Ken Waldron, a psychologist from Madison, entitled Game Theory and the Transformation of Family Law. It's available on Amazon, and game theory is something that I have written and spoken about a number of times. We'll just gave a presentation on it to the Ozaki Bar Association, in fact. The difference between my presentation and Allan and Ken's book is my presentation is the equivalent of, I'm going to be generous to myself and say first grade. I think Allan and Ken would say it's more kindergarten. Theirs is minimally master's degree level and maybe PhD level. So you might want to start with the, if you're interested in it, in the lower levels. And you can find, if you go to my website, under articles, at least one, probably more like 2 or 3 articles I've written about the application of game theory to family law. Game theory, by the way, is not, poker or games on TV or anything like that. It's a field of economics, of behavioral economics, that's applied by economists to the macroeconomy. There have been several Pulitzer Prizes awarded in the field, including John Forbes Nash, The Subject of a Beautiful Mind, about the application of game theory principles to economics. What my articles do, again, at a grade school level at best, and Kevin and Allan's book does at a much more advanced level, is apply some of these theories and strategies to family law. It's a terrific book. It's available on Amazon.com. And then most recently, and I have a comment about it in this month's Flu, is a friend of mine, Carrie Silverstein, along with Larry Waldman, wrote a book. It's not on family law, but it's a terrific book called Overcoming Your NegotiaPhobia. Love the term, in terms of negotiations in various different areas. There's a chapter on divorce that I proofread for them and gave up some suggestions. Appreciate their comments about me in the acknowledgement section. And the subtitle is Negotiating Your Way Through Life, because there are lots of areas of life as well where we engage in negotiations, most particularly with our spouses and with our children. And the book has all sorts of interesting areas from a non-legal point of view in terms of where negotiations are helpful and useful in that area, and how to be a better negotiator. The reason this is important for us as attorneys is we are involved for a minimal amount of time in a very critical part of our clients' lives. And what we do in that critical part of their lives can affect what happens later. If we're dealing with people who do not have children, then it's helpful to negotiate in an appropriate manner just because we're professionals and helps us get to yes. But when there are children, be the children minors or adults, it doesn't matter, these people are going to have a life afterwards. And what we do and how we do it can be helpful or destructive to them in being able to deal with each other and have a life with each other down the line in the future. You know, we're used to people coming in and saying, I'm never going to talk to that person again, and he's a liar, or she's a cheater, and we're never going to have a relationship. But in most cases they are, because they have to. They have to deal with each other. They're going to have graduations, hopefully weddings if they're real lucky, grandchildren, which I can tell you is a terrific thing to have. And if they don't get along, if they can't find some method for communicating, for dealing with each other, for treating each other in an appropriate manner, it is their children that are going to end up paying the price for it. And that shouldn't be. The children really are innocent. They didn't choose them as parents. They didn't choose for them to get married. They didn't choose for them to get divorced. And negotiating better for these people, not just positionally, although in certain cases it's perfectly appropriate to do that, but handling the entire case in a manner that's conducive to their future relationship is many times more important than the specific dollars we earn for them in the settlement. get more dollars, get less dollars, money is spent or money is earned, and in most cases a few years down the road, and sometimes a few weeks down the road, it just doesn't make that much difference. What does make a difference is the attitude they have towards each other, the feelings they have towards each other, and their ability to communicate, talk to each other in a civil and appropriate manner. And what's interesting about it is negotiating in an appropriate and professional manner, and I'm going to use a double negative, so forgive me, is not only not harmful, let's do it positively, it's conducive to a better financial settlement. So it's a win-win all the way around. You actually do better for your client on a financial basis, as well as help them in the future in terms of as parents. So don't think that you know everything. I sure don't. The DCI seminar a couple weeks ago was terrific. Learned new things there, and I look forward to other seminars and programs and other books in terms of learning more. We're constantly should be seeking ways of learning and making things better. Any of those three books, I think, would help. And as I say, start with Fisher and Urey no matter what you do, and from there, find some other material to help make you better. If you choose my book, I'd love to autograph it for you. And but choose a book, seminar, program, or something, because we owe it to our clients to not just negotiate a settlement, but negotiate a settlement in the best way possible.